Okay, it's showtime. It's 1 o'clock, so we're going to get started because you have two lawyers up here who like to talk. So we're going to get started because we were just trying to figure out, okay, how much time do we have on each section that we're going to do. So we want to start by welcoming you to the conference. Appreciate your interest in dealing with the children and doing specialized issues for kids. This is something that Matt and I have done. So we're going to briefly introduce ourselves I'm going to go first.
Please do.
So my name is Jennifer Layton. I'm a senior best interest attorney in the 12th Circuit, which is Manatee County, Sarasota County, and DeSoto County. I've been with the program as of now about 16 and a half years. I have found my niche. I don't plan to go anywhere until they kick me out. And I haven't given them a reason to kick me out yet, so I'm good. I think if I have a couple more years, I can retire. I think that'll work. So I have done, Matt and I have done trainings for IL for the last 3 or 4 years. Mm-hmm. We do Fostering Futures, and we do some volunteer training for IL. So we'll try to give you as much information packed in a very little bit as possible. I do want to tell you there are handouts that we may reference. They're on the app, and they have been downloaded, and you have those available. The only thing we have provided you in a paper form today is the PowerPoint, because I don't know. I like to take notes. We've gone paperless in our office, and I can't help myself. I still have to print out things. So, Matt.
Good afternoon. My name is Matt Bachman. They gave me a microphone for the video camera. I've never really needed a microphone. I hail from Tampa. I'm in the 13th Circuit. I'm also a senior best interest attorney, board certified. As Jen said, we've been doing this for a while. There is a lot of information that we're going to pack into today. We're going to tell you everything about what you should be doing based on your role with teens, when you should do it, and a little bit of how you should do it. We're going to give you the eligibility and benefits for teenagers based on certain criteria. And then we're going to talk a little bit about how you can really become moving from an advocate to a mentor. So with that, by a show of hands, how many volunteer guardians ad litem do I have in the room?
Sweet.
Wow, you're my group. Thank you for being here. That's awesome. That makes our job a whole lot easier.
Thank you for being here today, but thank you for volunteering, because Matt and I could not do our jobs without you. So,
how many guardian ad litem staff? All right. Any CLS attorneys?
Yep.
Good. How about any DCF or CBC? Okay. Great. Welcome. Who else? Best interest attorneys? There we go. Where are my BIAs? Welcome.
All right. Okay.
Yep, going back.
I think you already did the why we're here.
Sure.
Okay. So why dealing with IL is so important and dealing with teens is so important. I know most of you have heard we have several teen advisory groups in the state, and the idea is, we've learned a lot about why are you making decisions for us without us. So nothing done for us without us, and I think that that's really important. So what we try to, when we look at teens, we have a lot of issues for teens that we don't have for the other, younger population. We a lot of times we have educational issues because with trauma, as we're all learning, the trauma, and we've all learned the trauma informed. Kids who have suffered trauma suffer in school. How many moves kids go through, they suffer in school. So a lot of times, a lot of our teens are suffering from have education issues, and some of it's, are they going to graduate? How can we get them to graduate? How do we help them get their credits? What is it that we can do? So we have, basically, I think that those are the issues that we see that deal with our teens the most: substance abuse, pregnancy, DJJ, and residential, and being normal. Everybody, I think, is aware of the idea of normalcy and trying to help teens be as normal as possible and providing them with every opportunity that they can have in order to not stand out as foster care is a placement. It shouldn't be a status of life. And unfortunately, for our kids, it's a status. But the idea of normalcy, and that's why the law changed, and that's why everybody is working, when we work together to make sure that those normalcy issues are met. But again, with normalcy, with driving, with dating, with participation in their own hearings, in their own life, and permanency in decision makings in their future. I just want to talk very briefly about this because the law changed relatively recently, actually just changed, became effective immediately with the change. How many of you deal with kids, teens, and they have delinquency issues? Exactly. I was hoping that number would be lower, but I was expecting that number to be exactly what it was with your hands. Because we have a lot of our teens, because they have all the other issues that we just talked about, they also are dealing with delinquency issues. But with the change in we're not appointed. The program's not appointed in a delinquency, and sometimes you have DJJ personnel who don't. Okay, how many agree with me that the guardian ad litem is the person that knows the child the best? Amen. So I think that when you're talking about a child, when the DJJ and the court is trying to determine, delinquency court is trying to determine the best type of placement, the best type of rehabilitation, because we know delinquency is about rehabilitation, and we know it is about helping the child. It's not supposed to be about punishment. It is supposed to be about keeping the child safe, keeping the community safe, but in a rehabilitative manner. So the idea is that children now are involved with both of them. You are not a party. As a volunteer, you are not a party to the delinquency case. However, with the recent change in the law, the guardian can now, the volunteer, and I tell you, this is a change in our nomenclature. So when I say gal, it's because I've been doing this for 16 years, and it's been gal all along. And we're trying to change to volunteer child advocate because that really identifies what you do completely. You're a volunteer and you're a child advocate. So the title itself is perfect, but this old school brain of mine is having a hard time making that change. So you're going to see a VCA up there, but you're going to hear me say gal sometimes. But you can ensure that the court has up-to-date information when they're making decisions about when the youth transitions, what type of DJJ facility, as well as transitioning out of the DJJ facility back into the community, into a foster placement, into what type of placement. And then you also, I just want to remind you to be cognizant of the attorney-client relationship, because delinquency is about an adjudication of guilt. Again, it's supposed to be rehabilitative, but it is an adjudication of guilt for the child, and that child has an attorney, the youth has an attorney, and that is an attorney-client relationship. You do not have that confidential relationship. But just now, we want to know that it doesn't expand your role, but it gives the delinquency court now can receive and consider information from you. You can be notified if the youth is placed in a facility or when the youth is going to be released from this facility, and the GAL program is added as a community reentry team. So the idea is for us to know and to be active and to be able to provide information.
Let me say just a little bit more about that. Part of the attorney-client privilege that they enjoy is also to understand, as the youth, to understand, are they going to plead to a certain something? So you might, as a volunteer, feel that it is imperative that this youth go to a program where they're able to be rehabilitated over the next 18 months because they're not only maybe self-harming, but they're really doing some bad things in the community. That's not your role, though, to say to the judge, I really think you should throw the book at him. That's something because the judge is going to listen to the plea deal, as it were, with the attorney, with their public defender. So although you can give your input that it might be in the child's best interest for that to happen, know that if that doesn't happen, it's not because the judge is looking at you as a less vocal person, but realizing that the judge has a lot of other things that their attorneys know that you're not going to know. We're going to maybe hold questions to the end because we're not sure if we're going to make it through. One other thing that I want to talk about when we're talking about this youth, and what I like to say is we're trying to meet the youth where they are. So how many of you know 15-year-olds that act like 5-year-olds? And how many of you know 15-year-olds that act like 30-year-olds? So what we need to know is that if we have a stack of 15 or 5 15-year-olds here, we don't know where they are in their transition from adolescence to adulthood. They could be at the point where they have been so traumatized that they're back, you know, as a 5-year-old or as a 10-year-old. And so we need to meet them as if they were a 10-year-old. Or we have a 15-year-old that has been so parentified that they act like a 30-year-old, where they feel that they're sexually competent. They feel like they can go out and get a job. They feel like that they can take on responsibilities that we might think that is not age appropriate. We might think that it's not age appropriate, but that's where they are. So we need to meet them there, and we need to discuss with them at that level. There are going to be so many times where you, as their guardian ad litem, believe that what they're doing is wrong, and you're going to probably tell them that that's not the best way to do it. But guess what? They're going to do it anyways. So instead of telling them, don't have sex, don't have sex, don't do drugs, unfortunately, we have to have the conversation of, let's make better decisions so that if you're going to engage in unhealthy or unsafe activity, let's find a way to make it more safe, or let's find a way that the next time we can help you make that decision better. Because believe it or not, if you don't meet them where they are in their development, they're going to push you away. But if you can meet them where they are, it'll be a lot better. And we're going to talk more about being a mentor and an advocate later on today. Jen?
Okay. Matt gives me this slide to do because I have a soapbox. And I get on it, and now I'm on it. Youth have every right to be in court, and if no offense to the case managers that are in here, and the CBCs that are in here, but because they don't want to be transported, and you don't have transportation, it's not a reason to get them there. They are a party to this case, just as we are a party. And can you imagine the court telling you, you can't come, or a case manager saying, you can't come. Your opinion doesn't matter. That's effectively what we're telling youth when we say you can't come, or we're not going to come get you, we're not going to transport you. Now, there are legitimate reasons for kids not to come to court. I don't deny that. But my soapbox is that youth, especially teens, should be making that call for themselves. And then we, as their advocate, as their best interest advocate, should be figuring out a way to accommodate what they want. If they want to show up, how do we accommodate them yet protect them? That's what we should be doing as their advocate, because they have an absolute right to be in court. They are a party. The court can exclude them for best interest reasons, but quite frankly, in my opinion, that should be a very limited situation when you're talking about youth that are in the system, that are going to stay in the system. And then ultimately, when we get down to, when we're talking about extended foster care, kids that are going to age out of the system. They're going to, so we really need them to be there. You have to, the court gets to make the determination whether it's appropriate. We don't. Case management doesn't. Parent doesn't. Child makes a decision. Youth makes a decision. And then if for some reason there's a major best interest argument against it, and we can put no protections in place, then we ask the court to make the decision that whether it's in the best interest of the child to appear in court in person, or can they speak to the judge privately, can they speak at the bench? There's all kinds of things. So we wanted to try to just get you thinking about the pros and cons of youth being in court. And I really do want you to focus on teens in this kind of, preteen 11, 12, and then teens 13 to 18. Do we want to write it down, or we just want to kind of take a shout out?
Let's just take a shout out.
Let's just take a shout out then, just shout out some ideas. We're going to do pros first. What's good about? Come up on my soapbox with me, somebody, please. It gets lonely up here sometimes. What's some good things about kids going to court? I'm sorry? They're informed. They can see the process. Okay, they can see the process. They have a voice. They're empowered. For the judge, okay. For the judge and for all the other people involved, okay.
They might buy into decisions made if they're participating.
Okay. So they have an idea that they can have some input in the decisions that are made in their life, and so that's empowering.
They can develop a trust with their advocate.
Okay, true. I hope they get that outside of court.
They get a feel of all of the different personalities involved, and sort of how the team works together.
Okay. And maybe understand the roles that some people play, because quite frankly, sometimes the role of a case manager is quite different than the role of a guardian, in a good way. You know, and I don't mean that in a bad way. It just means we have different roles, and understanding those roles and understanding why we make decisions that we make and case management makes decisions they make, because of the role that we have and how that role affects court. Just shout out. Accountability, shout out. Okay.
The child gets a big picture of the whole process, and then they're at the center of it, and everybody's there for their best interest.
Okay, good.
The child, since he is alone, because normally they clear the court, they have more reason to expose themselves to the judge and tell them what they feel and what they're going through, so the judge will understand better.
Okay. Okay, so the child is probably the best person to tell the judge, this is how I feel. Because if I'm telling the judge how Matt feels, I can do that. But Matt telling the judge how Matt feels is much better. So detriment, cons.
If it's not on a half day of school, they're missing school.
Okay, so they miss school, they miss their normal activities.
Too much drama within the parents, and a lot of confusion.
Okay, too much drama. What else? They may not like the outcome. Okay.
Trigger trauma.
Okay.
Expecting a certain result, and they get disappointed.
Okay. What else?
If I see their parents in a different way than they're normally see them, they may see them very negatively as a result of the court process.
Okay.
They
Ama-
see other terrible things because they sit in court all day and see the other traumatic things that others are going through and experiencing other
Okay.
Probably an outburst, might be upset, they had an outburst.
Okay. Okay, so a lot of what, it sounds like a lot of what the focus on some of the cons, or the focus of the cons is the emotional impact that the child could suffer from the result of either the decision not going their way, seeing their parent in a more negative light, observing all the other trauma and drama that occurs in the courtroom. All that having some type of an emotional impact on a young person. Can anyone tell me, how do we allow a child to come to court, a youth to come to court, and yet still protect them then? Pardon me? Yep.
Make sure they see what might happen, give them a roadmap so that when they get there, they're not surprised, they kind of know what's going to happen.
Perfect. Okay, everybody has your marching orders. You're good. We don't have to do this anymore. It's exactly right. We prepare them. I'm going to give you one example of something else we did. We had two young people who their father and their stepmother were involved in the murder of their sibling. They were, and the mother's spending the rest of her life in jail. The father took a plea deal and is spending a little less than the rest of his life. But they wanted to come to court. We were in TPR mode. They wanted to come to court. They wanted to know what was going on. They had a therapist. We didn't have them. We had them in the child room, even though they're a little older. We had them in the child witness room for the most of the time when we were waiting for our case. First though, we advised the court that they were there. So we asked the court to take the hearing as soon as possible, as close to the time it was scheduled as possible, which she accommodated. We had them in the child witness room so they weren't exposed to the rest of the trauma. And guess who was there with them? Their guardian and their therapist. Because the therapist understood that it was important the therapist also agreed that it was important for them to be there and to be exposed to this and see what they wanted to see and have that power in their life. So she agreed to be present. Can't always do that, I get that. But there are ways to accommodate a young person and protect from all the things that every one of you kind of mentioned, that mentioned something that brought up. We can protect them from the emotional harm. We don't want to re-traumatize these young people, but we want to empower them to make the decisions for themselves and to understand that I want this. I may not always get this, but I want this, and then have whatever protections we have. How many of you have therapy dogs? They're awesome. We have a therapy team. We have therapy dogs, and also think about that as a possibility, even for teens. We found out a teen's favorite type of dog, and found a therapy dog that was in the program. It was a German Shepherd. Got the person that had the German Shepherd, and that's the dog that came that day. You should have seen this kid was 14. You should have seen the look on his face when this German Shepherd showed up. The level of ease that youth had at that point was just something that you can't, is perfect. So just think about the things don't think about, we need to protect them and keep them out. We need to protect them, bring them in, and protect them still. That's what, sometimes you're not going to be able to do that. I totally acknowledge that.
Also, I think we can protect it before the therapy, so the therapist start preparing them.
Yep. Between right. Prepare them, talk to them about what a court hearing does. Take them to the courtroom when it's empty and show them around.
Yep. The only thing that I have to add is that's one of the ways that we do it before the judge takes the bench. We'll go in and say the clerk sits here, this lady that's typing over here is the stenographer. She's going to record everything that you say, and have them look at that. And again, just setting up the whole process and letting them be able to acknowledge it in their head before is one of the best ways to help protect the child, I think, or the youth, I guess. Okay, so now we're going to start going through a couple slides of this is what should happen in a perfect world with independent living for the various ages. We're going to talk to you about what the VCA, what the gal should be doing. We're going to tell you what the social worker or what the case manager should be doing, and kind of where they should be. So we're going to start with independent living is supposed to start per statute at age 13. It doesn't, and I acknowledge that. From ages 13 to 16, the CBCs generally have given the independent living duties over to the caregivers. So it's actually administrative code almost that the caregivers of someone that's 13 to 16 is supposed to be doing the independent living activities. So they're supposed to be teaching them how to do laundry. Their foster parents are supposed to be teaching them proper hygiene. They're supposed to be teaching them maybe how to grocery shop. If your kids are in a group home, oftentimes they'll have monthly or quarterly activities that they'll participate in, maybe learning about banking account, that kind of thing. They generally are not going to have a dedicated case manager to the independent living services. And independent living, ages 13 to 16, it doesn't matter what the goal of the case is. Just because if they have a reunification goal, if they have a PG goal, if they have an APLA goal, if they have an APLA goal from 13 to 16, you're in trouble. I'll be mad at you. But if they have, no matter what their goal is, they should still be learning basic independent living services. Guess who else can really help? The guardian ad litem can really help. If we have a transportation policy that you are probably aware of. I never ask that my volunteers that they need to be transportation certified, but if you can and if you find that that's something that you're willing to do, being transportation certified can really help because you'll be able to help out with some of these things. You could take them to a bank and teach them a little bit about some money issues and those kinds of things. The other thing that you can do and that I've always noticed when I drive with my teens is that if we're looking and talking at each other, they don't like to say much. They say, yeah, how's school, fine. But if you're sitting in a car and you can't, and you're driving and they're kind of doing their own thing, you can have a complete conversation with the person. And I don't know what it is. Like just because we're not looking at each other, suddenly, they'll tell me their life story. And so it can be a really empowering thing. What the social worker should be doing, again, an independent living worker may be assigned. I know that they are not assigned in Hillsborough County and in most of the surrounding counties they're not. There's supposed to be in their JRSSR a statement from the caregiver about what the caregiver is doing to help do their independent living. Again, this isn't a perfect world. I don't see that statement very often. And as I mentioned, fostering group home parents are responsible to ensure that they learn and master independent living skills. And again, with your role, to ensure that they're receiving some sort of independent living. So when you're doing your home visits, ask the caregiver, hey, have you taught them how to do laundry? Or is that something you want them to learn? Or is that something you can help them with? Or, hey, next time you go to the grocery store, can you let them pick out what they think a healthy meal looks like? And then maybe try to teach them that way. So that could be part of your role. As I mentioned, consider becoming approved to transport. It can really facilitate your relationship with them, and that's why we championed that change in the statute, was to allow us to be able to transport children. Respect and facilitate the youth's cultural connections without going too deep into it. Again, this is a great chance for you to build a relationship with them. If you have someone who is of a different cultural background than yourself, find out if there's at the local library, if there's at a museum that's near you, if there's a festival that's going on that celebrates their heritage, take them to it or meet them there. You know, whether it's Black History Month or Hispanic Awareness Month or whatever it is, Irish Festival for the redheads. Take them to that and help them to be encouraged about their culture. And of course, when you submit your JR reports, your guardian ad litem reports to the court, address independent living in the normalcy section a little bit. Find out what they have been doing or what they haven't been doing and make some recommendations on what needs to happen.
All right, so then we as we get to 16 to 18, we actually see it's not so much a may anymore. We really do usually see at this point is when the CBC gets involved. And quite frankly, not picking on the fact that just there's not a whole lot of teens. I think when the IL thing started for teens and we started with IL, APLA actually could start a little bit younger and kids were aging out of the system a lot more so now than now, so that you really needed to prepare. My mom didn't teach me how to do laundry. My freshman roommate in college taught me how to do laundry because I dumped everything on the bed and she couldn't believe I was going to put all that stuff in the same load. So I'm just saying, so it's just the idea is that the idea is preparing them. And 16 to 18 becomes much more important because at this point in time, if you have kids in foster care, between the ages of 16 and 18. They could still have a goal of APLA. They could have a goal of adoption. They could have a goal of they're still trying to find a permanent guardian for them. But the idea is they're in foster care. We need to make sure that just in case they age out of the system, and I really do mean just in case, because we should still be looking for a more permanent solution for them until we can't, until we don't. But they must address the options for the young adult to obtain all of the following services: housing, healthcare, employment, education, and personal support services. If the youth, and we should change these childs to youth, if the youth is planning to leave care upon reaching age 18, the transition must be approved by the court before the child leaves care. So they have to have a transition plan. And honestly, the transition plan has to be made for the youth. Okay, it has to be specific to that youth. I have seen transition plans that could be a young woman, could be a young man, could be a young man who is struggling with his sexuality and trying to make decisions about who he is, could be a young Black man, a young Hispanic woman, because they're not different. They're not specific enough. They're not specific as to what's going on in that youth's life and what issues are facing that particular youth. So just when you're, because you should be involved in the development of that transition plan, just make sure that when you read that, if you hand that to, if someone handed you that, you would be like, that's my kid. Make sure you can do that. If you can't say, that's my kid, just by the description that's in there, not even looking at their name, then that transition plan's not effective enough because it's not identifying enough that particular child. So what we're looking at, they have the social workers, the CBCs have similar reporting requirements for the case manager and the caregiver about reporting what IL services have been done, what the child is learning, the transition workers' responsibilities, and this is, you can see that they educate, they attend court hearings, they schedule and participate in the transition plan meeting. within 6 months of the youth's 17th birthday. You do know that we have more JRs as well. Once a child turns 17, going to be 17, you have to have a JR within 90 days of their 17th birthday, and then you have them every 3 months, because the idea is they're getting ready to age out, and a lot of the kids have said as they in the advisory councils that they were not prepared. They were not prepared. They were not prepared, and we need to make sure they're prepared. Because I got to delay my adulthood by at least 4 years. Sometimes I say I've still delayed my adulthood, but at least 4 years I got to delay my adulthood because I went to college. A lot of our teens are not going to go to college. If they do, wonderful. They have that ability to do that. Let's make that happen for them. But some will not. Some will go to trade school. Some will go out and be working right away. And we need to make sure that they are prepared to do the best that they can.
So one of the things that we also talk about from ages, it's actually about 15 now to 18, is the driver's license. And we just bring this up a specific special slide because of the hard work that the Guardian Litem program has done in the Keys to Independence. How many people have heard of Keys to Independence? Oh, that's good. Most of you have. So Keys to Independence is a program that allows youth to find more normalcy by providing them the ability to get their permit, and funding for that. It gives them funding to take their various tests online. There's a drug and alcohol test, and there's another part of the driving test that they need to do. It pays for some of or most of their driver's education. It then pays for them to take the test, and it also provides a stipend for insurance after they get their driver's license. It does not provide a car, so unfortunately there's not that. But some of the things about that I wanted to hit on this as well is that it used to be just for kids in foster care, but now the legislature changed it so it's any kid that is in out-of-home care. And it's kids, if they're in out-of-home care and have started the program, then they can stay in the program for 6 months post-reunification, if that happened. Additionally, it allows for the Guardian ad litem to sign for the driver's permit. So if you want to go down and get a driver's permit for your youth, you can do so. It also reduces liability if you want to teach them how to drive. So some of you guys would say, over my dead body. I won't teach my own kids how to drive, much less some other child or youth that's been traumatized, but you get all of that is your decision. If you want to help. And actually, if you think about it, I mean, I got my driver's license 2 days after I turned 16, and I have a twin brother, and so we got a $700 car back in the day that had carbon monoxide problems. But let me just tell you, we all thought we were going to die. But we had a car, and it was so freeing for us to say we're going to go to the grocery store, and just be able to go. And it's so normal for kids to have a driver's license, so it really can help out with normalcy.
And just like our parents controlled when and how often we could drive and where we could go and managing our driving privileges, so too caregivers for the teens in care get to do that. Handing them a driver's license isn't handing them the keys to freedom and to do what they wish. It's still the process of the caregiver, reasonable restrictions, the reasonably prudent parent standard for foster parent. What would a reasonably prudent parent do in a given situation? But trying to establish that level of maturity as well as level of trust and respect still requires the youth to demonstrate a level of maturity and the ability to be trusted with the vehicle. So,
yeah. Just a little bit more, as Jennifer had talked about, when we hit 17, that's kind of like, it's almost, you turn 18, you're supposed to be an adult. That doesn't happen. But when you turn 17, there are specific things that statutorily need to happen. And I will tell you that it's my experience that they don't without a little bit of coaxing, and the Guardian ad litem is a great coaxer. We know that, a great advocate. At the age of 17, there must be a JR, as Jen said, within the first 90 days. There statutorily needs to do that. So if you don't see one set, contact your best interest attorney and get one set, because they have to have one. And in that, it must address specific permanency plans and options. There is supposed to be, from the case manager, there's a special addendum for 17-year-olds that have transition questions about a specific plan on how this youth is going to, if the youth is going to age out of foster care, how it's going to be done. And it needs to be specific, as was stated, finding out exactly what's going to happen. Is it apartment living? Is it extended foster care, which we'll get to in a minute? Is it, are they going to go back and live with their parents? Are they going to go live with someone that might have been denied a home study, but once they turn 18, that's where they're going to go? Those are things that need to be in there. There's also a thing that you can help to do, that your best interest attorney can do as kind of a matter of course. There's a thing called the disability of non-age. That's lawyer lingo for saying that someone's 17, they can't sign a contract, right? So anybody that is under 18 can't generally get their own bank account, they can't sign a lease, they generally can't get a credit card, rent, pay rent, that kind of car insurance. Your attorney can go in and file a motion or get a stipulated order that removes the disability of non-age. So that means at 17 or older, they can now sign these things. They can sign for bank accounts. They can sign up for utilities. They can start signing checks. They can sign up for car insurance. And so those are things that that will help in the transition period. I'll go. What's the question?
It's more a comment, just
Okay.
so that everyone's aware, to be very cautious of that, because that also removes the disability of non-age for purposes of criminal proceedings. So if the child gets arrested, they will not be subject to juvenile proceedings. They will immediately get to adult court at that time.
Okay. I'm going to look into that. I'm not sure that it's 100% accurate, but
Yeah.
let me look into that. Yeah.
I know that the statute's very specific about what the order says, the disability. Is there, and certainly
Yes.
have a conversation if there's case law or statute.
We absolutely don't want to waive anybody.
Statutory site,
Yes.
then we can talk about it.
Yep, but we can look into that. But as we mentioned, you must have a very specific plan to age out, and the JR needs to happen every 90 days.
I decided it was time to move on.
Go ahead.
Anyway, so what we're talking about when we're dealing with kids at this age is the idea of change. Our role is always to be an advocate in court. But as teens get older and we're meeting them where they are and we're working with them, it's also the idea of being a role model. It's also an idea of being a mentor to them. You're not, in sense of a mentor versus a friend. I'm not going to use the word friend, but I want you all, we have a slide in here, it's called Memory Lane, and I want you just, while we're talking about mentoring, and I want you all to think about a significant adult in your life, that it could be positive or negative, but think about the impact that adult had, and why that adult had that impact on you. And that's what we're asking in terms of your role as a mentor, your role as a volunteer continuing to work. You're going to be the mentor. You're going to work with the transition to make sure that a transition worker is assigned. I know that in our circuit we don't have an issue with that. Once the kid is 16, they're working with, the IL team is on it. We still sometimes have things missing from JR reports. I mean, no one's perfect, but they do have that going on. So you want the youth to be involved in the work of their transition plan. This is not a plan being made by someone else for him or her. It is a plan made by a transition team that includes you as the guardian, it includes case management, includes an attorney ad litem if there is one, and it includes the youth. And anyone else the youth wants to involve in it. To develop a plan for their life.
Before we move on, I have a question about independent living skills training. I cannot be the only one in here with the experience that the child himself, one session was not going to check, I'm fine. She knows nothing about money. I'm fine. I don't need it anymore. I don't consider anything more of that. Anything you try to teach her to reading the bus schedule, I'm fine. I've seen that before. She's completely unreceptive to any of these skills training we do. I know better, I don't need it.
Well, I think that you continue to offer this, you continue to offer the guidance and you continue to offer the mentoring of trying to prepare them. Well, you know what to do, show me. ask to show you what I understand that you know what to do. Just show me, kind of ease my mind because I'm a worrywart. I mean, there's a whole lot of things you can do, and I know that, but you can't force a young person to sit down and work.
So many of them have that attitude that you discuss applying the academics.
Sure.
Go away, you're going to meet.
And
so-
I do understand where, sorry, Matt, I understand where you're coming from, that so many of our youth have that attitude, but I honestly think as you work your way and you become a mentor and you are constant and without bugging but being consistent, I think that youth do come around, and some never will. We're not going to be able to help that, but you just stay consistent. Stay the course. Stay the course, continue to offer, and continue to be there as a support. We're going to try to take some more questions towards the end.
Yep.
So let's move.
I was just, one of the things that I really think that part of your role at this age is to focus on small, simple, positive outcomes. So, for instance, for someone that's, for a youth that is getting ready to age out or transition out, it is mind-blowing the things that they're going to need to try and do. When you're moving, which I'll be doing at some point soon, there's a lot of things that you have to pack up and try and get to someplace. And then there's things that you have to turn off. Like there's things that you have to turn on. There's who do you have to call to get a dentist? Who do you have to call to get a doctor's appointment? So focus on little things. For instance, if you're able to go with them and say, okay, today we're going to fill out 3 job applications. And when you're done with that, celebrate that. Or we say, you know what, I'm going to give you 3 job applications. I'm going to come back in a week and have them, filled out, and then, give them a cupcake. Celebrate small victories with them, because if you try and eat the elephant in one bite, you'll choke. I think that's what they say.
I have never heard that.
You've never heard that before?
Ever.
I'm from Indiana, but we don't have any elephants up there, but I guess that's, I don't know. Making small decisions on their education, those kind of things, but just celebrate the small victories because they'll start to add up. Because if you don't, then you'll start to see more failures than you will see victories, and that's never a good thing. So we have a handout. Again, all of our handouts are on the app. We decided not to kill the trees. Talking about relating to youth and engaging youth. Remembering that they're in a time of transition. And so on the handout, it gives you some ideas on how to engage them and how to work with them. And knowing that they have to bridge the gap, as it says, between childhood and adulthood, and that it's different for every teenager. And so what we say when you're working with our teens, it's fantastic because it can be so rewarding and it can make you hit your head against the walls over and over again. But the youth has to move in their time. They can't move at your speed. Whatever you want for them is fantastic, and help them to get there, but they're going to do it in their own speed. And you want to make sure that you engage them during the entire time. One of the other things that when I talk about relating to youth is, as we all know today, all of our youth have cell phones, and if they get their cell phone taken away, then they're hopping mad and running away from home or something. But so yes, as a volunteer or as a case manager, you go out and you see the kids once a month, but you can be in contact with them as much as you want to. We don't try and limit that kind of thing. So guess what they all do? They all text incessantly. So shoot them a text, find out how they're doing. Just engage with them using electronic media. If you feel comfortable using social media, if using telephone, although I don't think people answer telephones anymore, they just text. So there's ways to engage the youth, but we need to stay engaged with them because they're transitioning at different rates, and sometimes it's real fast and sometimes it's going to be pretty slow. So what we want to talk about now is the difference between advocate and mentor, and kind of the shift that we want you guys to notice and to be. So what I want you to do is take about 3 minutes in your round tables, and I want you to talk about what is an advocate.
Go.
Go. This is the interactive part. Give you another 30 seconds.
Or if you're ready, what we're going to ask you to do is have the same conversation about what is a mentor. what are the characteristics of a mentor? So just kind of transition right into that conversation of.
So talk about what's an advocate, or a mentor, I'm sorry, a mentor. All right, we're going to have you guys report out just a little bit. So I'm going to call on a table and somebody tell me what they thought in the back. What's some words to describe an advocate? What did you guys come up with? Yes?
Adult voice for the child, coordinator with agencies, protector of the child, and speaking in the child's best interest or even if the child doesn't want that.
Very good. One other table that's going to do advocate. How about the other table in the back? Securing services for the child, that's good. Advocate usually sounds like something that's very much an active thing, right? It's something that you're doing. It's something that you are trying to persuade someone. Would you agree with that? So then how about mentor? What did you guys come up with mentor here?
Mentor, we came up with it's a more confidential relationship. It could be between the child and the team and the mentor.
A more confidential relationship? Okay. How about this table over here? Mentor.
We had as a guide or exposing the child to different situations that they may not have been exposed to in the past.
Okay.
Behaviors
Modeling behaviors as a teacher. Okay. And one more for mentor. How about the table back here? Yep. Those are all really, I think, very appropriate things. As you saw kind of with the last slide, the kind of the Venn diagram, you can see where advocate and mentor overlap, right? You can see where being a strong advocate may not be the same as being a strong mentor. And if you're a strong mentor, sometimes that means that your advocacy role maybe diminishes a little bit. Of course, we always tell our volunteers, our guardians at Litem, that as a volunteer, you are always going to be an advocate. That's job number one. You will always be an advocate. But as you start to transition, as the youth starts to transition into adulthood and continues to get older, they're going to be advocating a lot for themselves. And I'm not saying that we need to diminish our role and advocate, change our best interests. But we're going to also start mentoring them so that when they go ahead and make those decisions, we're there not necessarily to tell them whether it's right or it's wrong, but to help them shape their decision and make it so that when they make that decision improperly, which they will, you'll be there to help them and to then shape what the aftermath of it is and to hope that they're not going to make that decision again. We talk about becoming a significant adult in a youth's life. One of the tenets, especially here at the Guardian Ad Litem program, is that we want our volunteers to become not only be the best advocates that they can be, but once the youth leaves care for whatever reason, if it's possible, we would really like you to be an adult, a significant adult. Someone that can be there for them if they have questions. Somebody maybe that can help them, because of course when you turn 18 you don't know everything, but that can help them out. And to become that mentor and that maybe somewhat of that teacher, to model some behavior for them. It's not to tell them what to do and what not to do, because they're going to do it anyways. But it's to be there to help. Instead of what I kind of think of, as you said, the advocate is kind of out in front, leading the way. The mentor is more walking side by side and helping them that way. So we want to make sure that we do continue to work as a mentor.
I do want to give one caveat on the more confidential relationship. With a young person, nothing you do with a young person is confidential. Nothing they say to you is confidential, and you cannot hold that as confidential at any point in time. And you need not be telling them that it's confidential, because it's not. And our job as volunteers, as volunteers, as the Guardian program, is to report to the court. And if a youth tells you something, they say to you, but you cannot tell anyone, you have to make sure they understand that you may have to. Okay? you want to develop that level of confidence that they can share with you, but in certain circumstances, you're going to be required to report it to the court. And because nothing in that relationship is confidential. And we already did this. We were going to do a task, but we figured that it was just, it would take time that we want to spend talking at you.
Right.
But talking to you about the extended foster care. But think about when you are thinking about your youth, and then you're thinking about someone who made a significant positive impact in your life. Think about how that person did that, and think about how the best way that you can do this for this young person. And
then also, if you think to yourself, another part of this is self-realization. Most of you, as you sit here today, if we had time to finish, to go through this exercise, we'd have you sit and talk about some of the significant adults that are in your life and what made them significant. And we were going to have you do 2 or 3. And I'm betting that most of you could come up with 2 or 3 or 5 significant adults that helped to shape the way that you are today. And I bet that if you talk to our youth who are aging out, they won't be able to come up with one.
But please, when you're thinking, you can do this, you can do a memory lane kind of thing with your youth and find out. Because quite frankly, I say positive because I want you to think of, I want your role to be a positive, significant role for the youth. So I want you to think of the positive people. But you can also, I bet you, Matt says that we can think of 3 to 5. This person right here in front of you cannot. I cannot think of 3 to 5 people in my life that had that impact, but I can think of one very specific one that was a negative impact that shaped my life. And a youth is going to have that. Our youth, they're going to have somebody. But it's going to shape their life, and you as a positive impact then want to be the person that, okay, I think I turned out okay. Okay, even with the negative influence, I think it turned out okay. My mom actually thinks I turned out okay. I think she's proud of me. So the idea is that a negative impact, a negative person in your life can have an ultimate positive impact in how you live your life, and helping your youth see that can be an extremely valuable lesson that you can help by being that positive role model and say, hey, take that negative experience and make it into a good one. Okay?
These are just some more points about mentoring significant adult. Just treat them as a partner and help recognize their strengths, build on them, know that there's differing backgrounds and different approaches. Remember that healthy disagreements are healthy. Work with them on their hopes and dreams and ideas, and that's one thing that we also, Jen and I have talked a lot about in some other seminars, is do some dream building, some goal building. Sometimes we never ask kids, what do you want to be when they grow up, when they're in foster care? Find out, what their goals are for the next year, the next 5 years, and see if you can start to put together kind of an action item that maybe you could help them do that.
And what Matt said earlier about little steps. So think of the big goal, and then, okay, this is your goal. This is where you want to be in 5 years. What do we have to do in the next 5 months to start that process? And then after 5 months, what do we have to do now? So big goals with little steps. And I will tell you that I know that we have difficult youth. Please know that I am not minimizing that. And some are more difficult than others. But if you work that process, some are going to come around. Not all, because we can't reach everyone, unfortunately. So.
You can go ahead.
All right, now we're doing IL for 18 to 23. And the idea of independent living for 18 to 23 is basically there's extended foster care, because the youth now has the ability, because here's what happened. There's a lot of studies that have been done about the increase in homelessness. The largest increase in homelessness population at any given time for the longest time is a foster care youth turning 18. Because for the longest time, it's 18, see ya. We have families. I mean, I know I have friends that their parents did that to them. But the foster care system did that to them. Not That's just the way the foster care system was. But now we have extended foster care, but we also have, we have the tuition waiver, we have Medicaid available until the age of 26. We have extended foster care, I believe that goes to 21 unless there's a documented disability, then it is 22. Post-secondary support services, which is 23, and aftercare. And the tuition waiver can go, how many years are, it can go all the way up to grad school.
It can, yes.
You know,
Yep, it goes till 28.
28, 29. So if you have kids that have any interest in actually going and having an education, get them to go. Coming out of school without debt or with little debt, because you still have to buy, you know, there's some things aren't going to be covered. But if you have a youth that is interested, encourage that and help them move that forward.
So in the next 15 minutes, we're going to give you what we kind of think is the bread and butter, and a lot of people came here for. So we're going to go through all of the programs and eligibility requirements for youth who are aging out of foster care. As mentioned, extended foster care was started not too long ago because we were one of the only states in the nation that kicked our kids onto the streets when they turned 18. Most of the other states had an extended foster care program. We finally came along and met up with the times. What it does is it extends jurisdiction for the youth, but there is eligibility. So in order to be in extended foster care, on the youth's 18th birthday, their living arrangement, their placement in FSFN, which you're all probably familiar with FSFN? Okay. Their placement in FSFN must be foster care in order to be eligible for EFC. It doesn't matter if they've been in foster care all their life and then last week they went to live with Aunt June, then they would not be eligible for extended foster care. Some little workarounds, if your judges are willing to do it, my judges are, is if we know they need extended foster care help and they are with a relative a week before they turn 18, do a modification of placement to foster care and put them on a visit with their aunt. That just get it in foster care. Foster care has to be there in FSFN. Once that happens, then they have to also be working at least 80 hours per month or be in high school getting their GED, at a trade school doing something educational, or are participating in job skills, which is, like I was talking about, trade school types of things, or be unable to do any of those three things because of a disability, a documented disability.
Gotcha. Oops, sorry.
Oh,
gotcha.
that's right.
I was trying to help you
So
out.
here are some of the benefits. The benefits of extended foster care is, one, they're going to get living expenses like food and transportation, and they'll get an allowance. It's not very much. I imagine that most teenagers would think that it's nothing, but it could be $100 or so. It's probably. And then this is where we also get some sticky things, is they have to live in a supervised living environment. What does that mean? Well, every CBC has their own interpretation of that, or every independent living CMO has their own interpretation. What it's supposed to mean is you could think of a foster home or in a group home. However, if group homes have kids that are under 18, they generally aren't going to be able to take kids over 18 because then they would break their home studies or whatever it is. It could be an apartment with over a garage where there's a family living in the home underneath. It could be a dorm. There's ways for the youth to administratively challenge if they're denied a supervised living environment, or I guess at that point a young adult, but that's the statutory definition. It can be, but if that, so there, within the CMO that handles independent living, Aunt Jane would have to go through some sort of training to become like an EFC foster home. There's much less requirements for EFC foster homes, but there are still some licensing requirements.
Okay, so in addition to being eligible, if youth is in foster care and they can be in EFC, they can also post-secondary support services, PESS. Some of you have been guardians for a while and are aware of what RTI was, Road to Independence. This is the new version. It has been phased out. But again, there's eligibility requirements. They must turn 18 while residing in licensed care and have spent a total of 6 months in licensed out of care before turning 18, or they were adopted after the age of 16 from foster care, or placed with a permanent guardian after spending at least 6 months in licensed care within the 12 months immediately preceding the adoption or placement. I think that that is in there because we don't want kids to linger in care just so they get a benefit. And this kind of eliminates that last year of we're just going to leave these kids in foster care because we don't want them to lose their benefits. Because I don't know about you, but I'm going to stand up here and say it's not in their best interest to lose those benefits. So I'm going to do that, and I'm going to argue that, but I don't really want them in care. So there's a way to continue to make that happen and have them eligible for post-secondary support. And so they have one of the first two things, and they have a standard high school diploma or its equivalent. Okay?
So what do they get?
Huh?
I said, what do they get?
Yeah, what do they get? Here are the benefits. I do not know whether this amount has changed since we've created the slide, but it's while enrolled in college, university, or vocational school, that is a Bright Futures eligible at least 9 hours a semester. They can use it in conjunction with EFC, but they must live in an approved place. And they can return if voluntarily leave, or at some point they fail the requirement, they drop out of school and they just don't feel like going to school, but then they're no longer eligible, but they can return all the way up until the age of 23. Or 22, 23 with a documented disability.
So if the other things are not working, or the youth says, you know what, I am done with foster care, I'm done with foster anything.
How many heard kids say that?
Right. I never want to see you again. If that's the case, then we have what is called aftercare services. So what they can do is, as part of their transition plan, they could, for the next 90 days, generally the CBC is going to be willing to help pay temporarily some emergency services. So they might help them pay rent for 90 days, help them pay for utilities, security deposits, furnishings, that kind of thing. So there's about 90 days to bridge that gap once they age out. That means that they're not in foster care, or they're not eligible for EFC, or they're not eligible for PESS. So this is strictly for just temporary emergency type services.
And I do, just to make sure that you know that even if they're in extended foster care and they leave at the age of 20, they're still eligible for these after services. It's not, well, you had that, you're not eligible for this now because you left, you're no longer eligible for that. They're still eligible for this all the way up to the age of 23.
Yep. And we did not mention with extended foster care. With extended foster care, youth are able, and young adults at that point, young adults are able to opt in and opt out as many times as they want to. And the CBCs should be making it very, very easy for them to do so. We had a horrible tragedy in Hillsborough County where a young adult said that he wanted to come back into EFC, and they said no, and he committed suicide. So they said you have to work very hard with them, but they are allowed to get back in and opt back in. So what's your role during all of this?
Before we do that,
yes, go ahead.
I do want to just, I know that we've put these handouts on the app so that you have them, but I really do want you to look at, there's a couple that I think are really good. That will kind of the nuts and bolts of what these programs are. There's something called, it's a 3-page permanency at a glance, and it really does look at everything, the tuition waiver, the PESS, and it kind of lays it out, the eligibility, the implications, and other things. And then the Guardian Ad Litem program has an IL redesign so that it's kind of a checklist to go through some things on the IL and to make sure that with the different requirements, go through it with you, especially with your youth. If they want to go into EFC or they want to go into PESS, well, here you can actually go through and go with, these are the things that you're going to need to do and have. And then there was a foster care extension. I love flow charts, and I hope this is readable on your app better than it's readable on this picture copy, but it is a good flow chart of what is available and how those are interconnected. So I just wanted to make sure that I know you're going to look at all the everything, but those I really wanted to point out.
Yeah, thanks, Jennifer. We skipped right over those. So what is your role, or what is the guardian ad litem, the VCA's role? We'll talk about it, and what is the social worker's role? So if a youth has aged out of foster care and would like to remain in extended foster care, statute recently changed. They're now still going to get a face-to-face visit with their independent living worker, their independent living counselor on a monthly basis. So that is still that's going to happen. It used to be where they would just contact them via phone or show up every now and then, but now they're going to have to do more for those young adults. If you're still on the case, or if you're a guardian ad litem and you're still on the case, you can stay on the case and continue with monthly visits, preferably face-to-face. If they're in extended foster care, they're going to continue to have a judicial review every 6 months. You don't have to necessarily do a report, but you can always go. At that point, generally, not always, you'll have to, I think each circuit is handling it a little bit differently as to what the best interest attorney's job is once the kid turns, or the youth turns to a young adult. We'll just make sure the CBC is providing the appropriate services, and like I said, become a mentor, become a person that walks, side by side with them. So we wanted to debrief just a little bit and make sure that you guys knew or got everything that we wanted to talk about. We wanted you to remember to meet the youth or the young adults where they are. Remember that every time that you meet a young adult or a youth, it is going to be different, and they are going to have some sort of life trauma, of course, because that's how they got here, that you're going to have to understand. And we can't force them to know what we think they should know, or we can't hold them accountable, how about that, for what they should know, because they're broken young adults and youth. And so we need to meet them where they are, and then to help bring them along. We talked a lot about advocate, mentor, and significant adult, and how we think that moving from the advocate role to the mentor role is crucial in working with teens and young adults. Talked about all the roles, benefits, and eligibilities for 13 through 21, and we want you to be a part of your youth and your young adults' future.
Because I think sometimes when we work with teens, I don't know, when I was a teenager, I thought my mom and dad were the dumbest people on the planet. They didn't know anything, and I knew everything. I think I turned 25, 26, and I'm like, oh my God, they knew everything, and I knew nothing. Seriously, and I do think that our youth are like that. And sometimes your advice, your mentorship, and your assistance is going to go, or they're just going to toss it aside. But I guarantee you, a moment in the future, that positivity that you brought, that learning experience that you brought, that acceptance of who they are that you brought to the table will make an impact down the road. Whether it makes an immediate impact, I guarantee you, none of you are in this role that you are in for immediate gratification. None of you. So think about the long-term impact that you're having, especially on this population. And we have a few minutes if anybody has questions. Yes. I can't believe we actually have a few minutes.
I know, we thought we'd never get done. So let's start here.
Okay, I have a two-part question. Why is the IL services only available to kids that are in the foster care system and not all that are in the dependent system? And why isn't IL mandatory or automatically started?
When? Okay, the first part of the question is because the first part of the question is easy because the legislature hasn't mandated it and it hasn't been funded. I think that's the easiest,
absolutely,
most direct response to that. Maybe the broader response is that if a youth is with a family member, with a family member or a non-relative, it's generally believed that those folks are the ones that are providing those services. Second part of that question
is it's truly contractual, which is hard to believe. But for instance, in Hillsborough County, our CBC contracts with a case management agency or a CMO to do their IL services, and their contract says that they don't have to provide it till their kids are 17. And there's nothing that says that they can't contract that way. So the legislature. I think that's the way it is in a lot of counties. There are some workarounds, but it's very few.
Yeah.
Well, so I'm in Hillsborough County.
Okay.
But I have a 17-year-old
Right.
The case manager never started the services, and now she's on the verge of aging out, and we're just starting the services by her having to submit a referral. So it's just a long process that should have been started a while ago.
That's exactly right.
Your factually specific is probably not so factually specific to your case. It's probably a little bit broader where other people have run into that situation. Our job and our role, when you have a 16-year-old on your, as one of your, you know that youth is going to be 16 soon. This should be a team meeting with you and your CAM and your CBIA, and having a meeting say, okay, let's make sure everything gets in the process, and then we should be advocating. That's the advocate in us.
Yep.
And I'm not saying anybody fell down on the job or anything. I'm not going to make that judgment but
Case manager. Yes.
You say it. I won't say it.
For our FCCs and our CPIs who are trying to tell the relatives or the fictive kins or friends about the GAP program and
Yes.
trying to get them to be technically level 1 licensed, a licensed care foster home.
Yep.
Is the EFC going to be available to those families who participate in GAP since technically they're foster homes?
So the question is, I don't know that we have that answer yet. I believe that it will help them quite a bit that if they are GAP licensed, I guess, for a better, if they're GAP licensed, that it's going to be much easier to turn them into an EFC home. But I think that hasn't been completely decided yet.
I just want to share a resource. Mid-Florida, I know they're in Polk County, but they're spreading to different counties. They do have a banking, and I just looked it up. It's from 10 to 20 years old, and it's a free checking account for them. And I know for a regular account, it's only $5 to open it.
Okay. And does the youth but the youth has have a cosigner to that?
That I didn't look up, but I've done it for my own personal children, so I don't remember if we co-signed. But it goes all the way up to the age 20, and any money in there gets a very high amount of percentage, considering I think it was like, it used to be 5%, but what are we doing now, 50%? So they do give the children a lot more.
Sure. And I do think that if there is the banks, we can do the research on a particular bank to see if what they provide. But what the disability of non-age does is it allows the youth to actually not have a cosigner on a bank account, and it's theirs, and they're the only ones that can sign on it.
Hey.
But thank you for that.
Hey guys, so we would love to take more questions, but it is 1:15 and this room is ready for 2:15. Good, my watch is off. It's 2:15 and there's a 2:30 that starts here. So thank you so much for coming.
Thank you.
If you have any questions, just let us know. Thank you again.